Hey folks, welcome. Dave Brannen here. Today we're going to be talking about some of the new changes that are coming into place in Ontario with the new Occupational Health and Safety Act. These changes are coming into effect throughout 2025. I tried to do a little research here just to brush up for today. Wasn't able to get through as much as I wanted, but I figure I'll still give you a little bit of an overview here, but there may be some things that I have to go back and check details on depending on questions people may have. All right, let's take a look at this. So here we go. So why is it important? We get calls from workers quite often who are dealing with psychological stress from workplaces that are toxic. So, people who are being bullied, harassed, excluded, mistreated, and those types of claims are now handled through WSIB in Ontario. However, sometimes your WSIB claim will get denied. Some of the changes were brought into the occupational health and safety because the law traditionally in this area has not done a good job on keeping up with how workplaces are changing. They're typically focused on physical aspects of work, physical health and safety, things like equipment, dangerous chemicals, trip hazards, that type of thing. Over the years, harassment and violence were added, but mostly in limited ways. So the big changes that came through in I think it's Bill 190, that was passed last year and it's being implemented this year, with some of the changes coming into effect just this month. So some of the big changes that are quite interesting, actually, there are now within occupational health and safety, it now covers things like virtual harassment, which is included explicitly now within OSHA. That means bullying through emails, texts, social media, messaging apps, all of it now counts as forms of bullying. Whereas before, it would be difficult to say some of this stuff was linked or not linked to work. It could get difficult. Now, also, the Act now applies explicitly to remote work. So protections extend to your home office as well, or if you're working remotely at the company. Oh, my dear. I don't know why my allergies, every time I start this, they start flaring up. I don't know if it's because I'm talking or what, but I'll constantly feel like I'm going to sneeze here. So employers are also now required to post their policies, occupational health and safety policies, digitally in order to make them accessible to workers, whereas sometimes those only had to be paper copies available at the office. Now, these may seem like small changes, but they do represent quite a major shift in how the orientation of how occupational health and safety is seeing itself. Now, again, these changes are in Ontario. I'm not going to address other provinces today, but this is something unique. Most provinces don't have these explicit changes. All right. So, in terms of employer obligations, employers must have a clear anti harassment policy. They have to provide a program for reporting and investigating harassment, and they must ensure that investigations are carried out even when the harassment is digital or remote. Employers must also keep these policies available, easily available to employees, including in digital format. Okay. And let's take a look here. Now, in terms of how workers' compensation handles harassment claims now, that's important to know because these two things kind of fit together. So, under the current policy, workers' comp in Ontario allows for claims for chronic mental stress. Again, this is in Ontario and some other provinces, but not this is not universally available in all provinces in Canada. However, even in Ontario, which is kind of a leader on this, there are still only certain types of mental stress claims that you can get compensation for. They have to be you have to have ongoing and substantial symptoms. They have to be supported by objective evidence, which is often difficult. And finally, there must be a DSM-5 mental health diagnosis by a qualified professional. DSM is just the manual that doctors use when diagnosing mental illness. So even then, WSIB can deny some of these claims if they think the stress came from things like discipline, poor performance reviews, changes in job duties, because they fall under an exception called reasonable managerial actions. So even if you have a bad reaction that arises from reasonable managerial actions or what are deemed to be those, then your claim can also be denied. So with workers you will often get denied WCB with these types of claims because often you'll say like bullying wasn't serious enough, there wasn't no medical diagnosis, it happened over Zoom and therefore didn't count, or it was through chat so it doesn't count. Um, or like I said, if you have these real symptoms but they arise from what WSIB deems as reasonable managerial actions, then your claim you fail and you can kind of fall through the cracks. How the new OSHA rules help now, it only helps in a limited way. It will not help in terms of OSHA cannot give direct compensation to workers. So the only way this will help is that it will force the company to do investigations and to basically address these issues. Whereas if you just go to workers' compensation and the claim gets denied, the employer has no obligation to do anything. Now, with these new rules, employers have to investigate these things. They can no longer ignore things that are happening virtually or by text or by Zoom. They can't ignore things that apply to remote workers who are now protected. They have to investigate and document the complaint. So while you may not be able to get compensation, you would have access to initiate a process, the power to initiate a process to have this being investigated, because workers are allowed to report these types of incidents to Occupational Health and Safety, and they will then investigate and determine if any actions have to be taken. Okay, so here's an example. Maria worked from home, bullied by coworkers on a WhatsApp group. She felt anxious, depressed, and couldn't sleep, but when she applied for workers' comp, her claim was denied. The board said it wasn't substantial and didn't happen in a physical workplace. Okay, so under the new rules, Maria's employer would still be required to investigate the WhatsApp bullying and document it. And the documentation could support her further workers' comp appeal and change the outcome. So that is an element I did forget to mention above. Like your workers' comp claims can be subject to appeals. So it's possible that the workplace investigation that the employer has to undergo could also help the workers' comp claim. So if you're a worker, what do you do now? You could get a copy. If you think you're having issues with harassment and bullying, you can ask for a copy of your workplace harassment policy. Keep records of the bullying. Like, you should be saving texts, screenshots, these types of things, especially if a lot of this stuff is only available on the workplace provided electronic equipment. You have to make sure you save this and have a personal record of it, because sometimes you might be terminated or whatever, and they grab all your stuff, and you lose all the evidence that you had of that this stuff was going on. Now, be very careful. Make sure you don't take copies of something that would be confidential to the workplace. So you do have to be careful about what information you keep personally as records for this type of claim. Okay, and obviously get medical help if you're dealing with these issues. Ultimately, your doctors should be the ones you get advice on what to do in terms of taking time off work or filing claims with workers' comp and that kind of thing. So just to wrap this up, that the new OSHA rules recognize the reality of modern workplaces. That was part of the purpose of this. Virtual and remote harassment are now fully covered. Employers must act, and that creates a trail of evidence that you can then use as part of a wrongful dismissal case or also part of a workers' comp claim. It could go directly to help workers who've been denied workers' comp in the past by virtue of you being able to use that evidence. All right. Now, if you need legal help, you can always reach out to a firm like ours or other employment lawyers to get advice on what to do in these types of situations. All right. Let's dive into some questions. I'm going to go check and see if we have anything on the forum. See if I'm desperately in need of a haircut, and that is happening tomorrow. So next week, you're going to see a guy with a much better haircut and trimmed up beard. So I'll be way more presentable. Getting kind of slack here. Working the summer kind of slows down a little bit. And I'm working from home, mostly in my home office here. So I'm not always wearing my suits and things. What am I looking for here? I'm looking for the forum. Let's see if we got anything new on here to go through. Yeah, it looks like there are some things. So you guys can help me answer these questions. Before we go there, we've got someone posting some questions here. So let's take a look. It says, after being on LTD for 6 years, I recently returned to the work with a different employer. Okay. And my LTD benefits have stopped. My previous employer with whom I was on disability has now offered a severance. Okay. Interesting. So this person returned to work with a different employer. LTD is now stopped. Previous employer is offering severance. This person wants to know, am I entitled to severance after returning to work following long-term disability leave, especially if the employer wasn't notified of my return? Generally, yes. Generally, yes. You'll be entitled to some type of severance I guess, do they not know? I guess what I would ask is, do they not know that you have gone and worked somewhere else? Maybe they don't realize that, because if you have actually just gone and worked somewhere else and the other employer doesn't know, that could be deemed as you resigning your employment. So the answer is, it's possible that they don't owe you severance if you've taken a job somewhere else and kind of resigned that employment. I don't know what they know. So whether you're owed severance or not is going to be very factually dependent on your situation. Generally speaking, like, you're not owed severance when you leave an employment. The only reason you are owed severance is if the employer terminates your employment and doesn't give you notice of that they're going to do it. So how it usually works is, rather than telling you, like, come back to work and we're going to terminate your employment in like 6 months, they will just terminate you. And instead of giving you 6 months notice, they just pay you 6 months pay. So this does seem like a sensitive situation here that you're dealing with. So it's possible that if you're already working somewhere else, the employer would not owe you severance, because you've technically, they could take the view that you've technically abandoned your employment or taken it by taking a job somewhere else. So it says here, if yes, if you are owed severance, the offer seems low. Would it be worth involving a lawyer to negotiate? They've also sent a release for me to sign. Well, the one thing I would want to make sure, you can involve a lawyer in these kind of situations, but the amount of severance that you'd be owed, I mean, it will depend. Again, I don't know how much the employer knows about your situation. So it may seem like a low offer, but if they find out that you have a job somewhere else, then they may pull it completely. Also, they may just sometimes maybe the employer does know you have another job and they just want you to sign a release because there is value to them in getting you to sign a release. So maybe that's part of why they're offering you a lower amount and they're happy to do it just to have you sign a release, and that way they don't have to ever be concerned about you coming back after them for anything. You would need to be careful about how the release is worded and whether, I mean, you were on LTD for 6 years. So, if I were you, I'd want to be careful that if there's going to be a reoccurrence, if there's going to be a reoccurrence of your disability, um, that reoccurrence often has to happen within 6 months or so. So people in your situation, you do put yourself in a bit of a peril because if you stay at the new job and work roughly like full-time type work for more than 6 months under most policies, that will just mean that your claim is extinguished completely and you would not be able to go back on your LTD claim that you were on before. The other issue you would have is if you're at a new employer and the new employer has group LTD benefits, you would not qualify to go on the new group benefits unless you've been working for that employer for at least a year. So if you make a disability claim within a year for the new employer, you're going to get denied likely for being a pre-existing condition. Okay. So there are just some complications here when you go back to work to a different employer coming off a long-term disability that long. You really want to be very certain that this is going, like, once you're getting, again, I haven't seen your specific policy, but with a lot of these claims, it's around 6 months, but I can't say that's what yours would be. You will want to be very careful about not sort of barely hanging on past 6 months and then technically extinguishing your existing LTD claim. If you were to fail in this new job and have a relapse within 6 months, you could potentially go back on your old disability claim with the previous employer. They just sort of reopen it, but just keep that in mind. Yeah, so you're saying they are asking for a release form. So yes, that is what they want. That's what they're paying for when they're paying a severance. But I don't know what the facts they know about your situation. So you'd have to be careful with negotiating with them. Um, Again, I can't give advice because I don't know all the details, and I would encourage you, don't post all the details in here. You could get legal advice on this, but and it probably is not a bad idea if you're thinking of accepting the release. You may want to have a review of it to be certain what you're signing and to figure out if you might be able to get more money from the old employer. But the other problem is like, I have to believe they don't really know that you have this other job, because the fact that you have a new job would mean that you are mitigating the losses that would come from a severance pay. So the fact that you have a new job could be mitigating the damages for the old job. Now, maybe what they're offering you is just the minimum payments owed under your Provincial Employment Standards Act. Sometimes they have to pay that, even if you've mitigated and found new work. So maybe that's what they're offering you. And if your new work is a similar pay to what your old work was, then you're not going to be owed much severance pay anyway, to be quite frank with you. So just take that all into advice. But if you want definitive legal advice that applies to your situation, you would want to get a one-on-one confidential review from a lawyer, because I don't have all the details, so I can't really advise you what's best. But these are great questions. Very great, very, very good questions. All right. Anyone else have anything to add on that? If not, I'm going to take a peek at our forum where I answer questions about disability law. Let's see here. All right. I got good news this week. I can't announce it. I'm not allowed to say anything about it until September. So I'm going to have to wait. But yeah, I got good news. But remind me if you're on these things and you're back in September. Well, you'll know in September because I'll announce it by then. But I can't announce it until September. Okay. Let's take a peek here. There was a follow-up here. I would like to book a session with your office. Should I book it with you or would it be with someone else? No, it would be with me. So what you would do is just go to our website, resolutelegal.ca, and just fill out the the easiest way is to go through the chat. There's a chat bot there that'll take you through. It'll answer all the basic questions. And that's probably the best way to go about it, is to go through the chat. Just tell them that you were speaking with me on this webinar and that you're coming here to request a free consultation. They'll get your details and we'll help book it. Now, this type of consultation wouldn't be a free one. You would have a free consultation with my team who could they would take you through all the options and things like that. But this would be a paid consultation, but they can explain it all to you. Okay. All right. We got another question here. It has been a year and I haven't heard from the insurance on a mental health claim. It has been a year since so haven't heard from the insurance for a year on a mental health claim, and they're on LTD. Why would the insurance ask for a phone update rather than send me a form to complete? Okay, very good question. In fact, I think you posted that yesterday, right when I was shutting everything down. I apologize for that. So there are benefits to both a phone update and just sending you a questionnaire to fill out. And the insurer will use them for different purposes. A questionnaire makes sense when they have just generic information they want to follow up on, and it is much easier for them to do it in bulk. So it's way easier for one case manager to send out like 100 questionnaires to people to fill out than it is to do 100 phone calls. So typically when they want to do a phone call, it means they want to get more specific information and be able to ask you follow-up questions. It doesn't mean there's anything sinister going on. It's just if they want to get if yours is a case where, so if they want to get an update, I was just looking at your details there again. If they want to get an update from you in more quickly, so maybe that this person reviewing your case is late and they're needing information. If they want to get more quick information from you and be able to give you follow-up questions just to clarify things, a phone call is way easier for them to do. Okay. It's much easier for them to ask you questions on the phone than it is for them to send you emails. You reply, then they reply, then you reply, then they reply. Like, it's very inefficient. Much easier for them to just get you on the phone, ask you questions. Oh, can you explain that further? What about this? What about that? Way easier for them to gather a large amount of information more quickly than to do emails back and forths or to send you a questionnaire. So if your insurer is asking for that, I would not necessarily see that as any type of negative thing. It's just more expedient for them to do it that way sometimes. Very good question. All right, let's have a look here. I'm going to share my screen. Let's try this here. All right, here we go. It says LTD approved. Yeah. LTD approved. Yeah. How much best practices to deal with any EI, AB supports back pay? I've been off work for a few months, short of 1 year, and finally got my LTD approval. I was on EI for 6 months and unfortunately had to go to AB supports for 1 month. The insurance company paid back pay to January this year, which overlapped with EI by 3 months and 1 month of AB supports. I don't know what AB supports. I'm not sure what they mean by AB. I'm assuming I will have to pay it all back. What is the best method practices to resolve this quickly and with the least amount of hassle? Well, you may have to pay back the EI. So I think what you would do is you would have to contact EI and show them the retroactive pay period where the retroactive pay went back to, and EI would let you know if they wanted a repayment. I'm not sure what this person means by AB. Had to go to AB. What is that? Does anyone have any idea what they mean by AB? I think of like accident benefits is a word sometimes. That would be like for a car accident case, but it doesn't seem like that's what they're talking about here. I don't know maybe they mean provincial support. AB, what does that stand for? Um, yeah, I have no idea. But I would go to you do the same thing. If you got AB support, you would go to the agency that paid that support and just let them know, here's my LTD claim. Here's the period that the retroactive payment covers. What, if anything, do I owe back to you? That is the responsible way to do it. And yeah, there's not really an easier way to do it other than that. I'm just going to write that in here. So I'm just saying you'd follow a similar process. There we go. Done. One question answered. Severance package. Here we go. So this one says, "Hi everyone. After 5 years of disability, I recently voluntarily went off on disability and started a role with a new employer. My company and I were initially has offered me a severance package. However, I think the amount is quite low. My question is, how much room do we usually have to negotiate a severance package? Is there any room at all? I'm figuring on whether I should hire a lawyer or get legal advice. Would it be worth it?" Okay. Yeah. So buckets is somewhat right here. It's not completely correct. So maybe I shouldn't like that. It's not completely correct. You still might be owed some minimal severance, but it's possible you're not owed any. It will depend on the facts. Yeah. So the jammer is asking the same kind of question. So this might be the same person that's here asking earlier. This might actually be the same person. Maybe it isn't. I don't know. But it is a similar question. So are they aware you quit? They don't owe you severance. I'll answer the question as if you didn't quit. I don't think the employer is required to give you any severance for terminating for frustration. They do in Ontario. They do in Ontario. They still have to pay the minimum amounts if you're terminated for frustration. Yeah, yeah. So I share the idea. Like I'd be worried the employer doesn't know that you now. That's why, like, they've made an offer to you. If you're not hiding any information from them, they've just made this offer to you, then sometimes it's available for you to accept the offer. But again, you should probably get legal advice on it. All right. Let's see what else we got here. Any others? Yep. Okay. What's this say? Hi everyone. I'm looking for some advice on dealing with my insurance case manager and wanted to know if the situation is normal or something I can push back on. All right, let's look at here. Okay. Is a case manager allowed to approve a shorter leave extension than what my doctor has recommended? Okay, let's read more. I don't really know what they mean. Context. My doctor recommended a couple month extension, to my current short term disability leave. But a few days before my case manager approved me for a 1 month extension based off the phone interview update of my progress. I provided my case manager with that update on what my doctor said and the completed the doctor's form. When I didn't hear back, I reached out explaining the doctor's appointment date. The case manager refused to look at my current leave window again, saying they won't review it until a few weeks before the 1 month extension window I already gave. Yeah. So technically, they can do whatever they want. They are not required to do what your doctor says. So what they're describing here is within their power to do it that way. They've already approved you for a window. They'll reevaluate that window when they get near the end of it. This is, again, like, this is within their power to do. I think it's more just for, I think it's just time. Like, these case managers are dealing with hundreds of cases probably. So it's just easier for them to just deal with this when it comes up again for review, is what I think is going on here. If in question 2, if they can approve a shorter extension than what the doctor indicated, are they legally required to provide their medical reasoning for the decision when asked by me? Not really. Not really. They had medical justification to approve the period they did. And so that's what they did. Your doctor's given new information, and what they're saying is they will consider your doctor's new information when it gets closer to that period, and they may or may not extend it at that time. So the fact that they've just approved the period they did was based on information from your doctor originally. Your doctor's given new information. They're saying, we'll reassess it when we get close to the end of this current window. I think this is reasonable within their power to do. Caro, who is a very long time person on here, who gives very good advice. It says, technically, we have to prove our continuing disability each pay period. That is true. So although it's annoying, I don't think there's much to be done about the length of the leave. For the case manager not reading your messages and so on, I guess you could escalate to a manager, but I probably wouldn't until it becomes egregious. Do document everything. Yeah, I agree. I wouldn't recommend escalating this. Just wait. Unfortunately, it's like they're going to assess it period to period. And once you get near the end of this period, when it's going to roll over to the next one, they're going to review your doctor. So I would check in at that point. Buckets. I love Buckets, his little icon here. When I first went on short-term disability, my case manager would approve 4-week durations, even though my doctor documented my progress as guarded with unknown and no return to work attempts. Yeah. So this is not unusual. They have a lot of power to approve benefits for periods with review. So again, based on what you're saying here, this is all within their power to do. And I wouldn't, it's very annoying for you. And I can see why it would be extremely frustrating as well. I absolutely see why this would be very frustrating. So I'm going to reply. Let's see here. Basically, so reevaluate once that window is closing. I believe this says, I believe. Is efficiency and expediency? I don't know if those are the right words I should be using, but it's more for efficiency. There. All right. Let's put my little. There we go. Okay. All right. Let's get rid of that. Enough of that. This thing is going strong, though, that disability claim forum. The thing has been going strong for many, many years now. All right. Let me think about if there's any other things we can talk about here before we shut down for the day. Interesting things. What interesting things have I done today? Boy, sometimes it's hard to keep track. Let me just have a look here. My notes, what I was doing today. What were we up to today at Resolute Legal here? Oh, yeah. Yeah, we had some interesting case. I quite enjoy a lot of discrimination cases. I don't like doing I don't enjoy doing racism cases. They're very emotionally charged, so I do tend to shy away from those cases and let people who are better equipped to handle them. I do quite enjoy though doing maternity leave discrimination cases. That is actually a thing, as you probably know. So we are having someone that might be hiring us who basically got fired right after coming off of a maternity leave, parental leave. That's an area where employers need to be very careful, because you have to think like you're putting an employee in a very hard spot if they're on off like for say 8 months on a parental leave, and then they show up to work and you fire them that day. Like, what the hell? Like, why not have told them 8 months earlier to give them time to try to find something out? Like, there's a bunch of things that it's not really well handled. So, the courts and the tribunals have come down pretty hard on this type of discrimination. So, these are good cases that I do enjoy handling. There was another. What else was I doing today? There's another case I'm missing on. It was. Oh yeah. Yeah, I really can't talk about that one. Some of these ones I can't talk about because the facts are too specific and would probably give people away. Maybe so. I can't really talk about those. But yeah, we get. Oh boy, like we get hundreds of people contacting us a week. I don't have the exact number in front of me, but it's hundreds. So we have 2 full-time people that all they do is take incoming phone calls, chats. They respond to people. We're in the middle of summer, so people are taking vacation. So like it's very stressful for them and for me dealing with all of the people contacting us. What happens is our people give consultations, and then we have a meeting every day where I attend the meeting, and the people on our intake and support team come, and they will review different cases that people have contacted us about, and we go through. It's okay. What kind of advice can we give this person? Is it a case we'd be able to take on? Like how can we kind of direct them in the best possible way? But that is how we handle it. But we're a small firm. Like I don't have any real desire to be this huge firm. We are small, like we do spread across Canada, but overall we're a very small firm. So we got a small staff, and those meetings take about an hour and a half every day. We're just sitting around in a Zoom meeting, going through all the people that have contacted us that day, and how can we get not everyone, because a lot of the people who contact us can just the support team are able to just answer their questions. They're not legal advice, that kind of thing. Then what we do, so the people that need legal advice, we talk about, can we advise them? Would they have to do a paid consultation? Here's what options they have. Could we take the case? A lot of people just want to know, can you take on my case? So we have to decide, can we take on the case? We can't take on every case because we have limited, we're limited in how many new cases we can take on. We can't take on like 10 new cases a week at our current staffing levels. It just would blow up pretty quickly. So we have to kind of pick and choose. We look for people who kind of share our values, who I think would be easy to work with, who aren't going to be abusive to the staff. We look for cases where there's a real villain on the other side. That's always good. So usually there's a lot of villains out there, especially if you're dealing with an insurance claim. But employment cases, we're looking for situations where the employer is really treated the person poorly. And there are some bad examples, very bad examples out there. All right. Well, I'm going to leave it there. I'm looking forward to the end of this week, be honest. I don't have much of a vacation this summer, but I'm going to be taking a few days here and there. Hopefully, you guys will have some relaxation this summer and enjoying the good weather. I will be back on here next Monday. So just come with your questions for then. And I do wish you all the best. Take care, folks.